Hi, everyone. Welcome to Buildings NY Unlocked and the next installment of our virtual education series. My name is Chaya Molberg. I'm the show vice president and general manager. I'm pleased to welcome you. If you have any suggestions for future webinars, please feel free to email us and check out our website, buildingsny.com. This presentation will be recorded and available on Buildings NY YouTube channel, as we have stored all of the webinar series. Today's presentation is brought to you by the Habitat Group. I'm delighted to introduce Heather Stone, the executive editor of the Habitat Group, who will be telling you more about today's topic and speakers. I'll be back at the end when we get into Q&A. Thank you. Thank you, Heather.
Thank you, Chaya, and thank you to Buildings New York for hosting this webinar. As Chaya said, I'm Heather Stone, executive editor of the Habitat Group, and we publish New York Apartment Law Insider, a monthly newsletter, and we'll be sending everyone a copy of that if you're not familiar with it, after the webinar. And right now, I would like to introduce you to our speakers today. Arun Paran-Bisekar and Michael Littman are partners at Sedrain, Schwartz Sedrain, Paran-Bisekar, and Littman LLP, a boutique law firm dealing in all types of litigation and disputes between landlords and tenants. Their practice ranges from administrative law to appeals, including work before the DHCR, as well as performing administrative due diligence for clients who are purchasing property. They cover the counties of New York, Kings, Queens, Bronx, and Nassau. Arun is a frequent contributor to New York Apartment Law Insider, most recently writing on how the Regina Metropolitan case affects landlords. Thank you so much, gentlemen, for being with us. And with that, the audience is yours.
Thank you, Heather, for that kind introduction. As Heather mentioned, my name is Arun Paran-Bisekar, and I'm a partner at Sedrain, Schwartz Sedrain, Paran-Bisekar, and Littman. And today we're going to be discussing responding to modification and accommodation requests from tenants with disabilities. Then we're going to deal with a few key topics today. The first is, what is considered a disability under the law? What are landlords required to provide for the disabled tenants? How to respond and evaluate claims made by tenants, some basic information on how to litigate claims, and some examples of typical accommodation requests. And at the end, we'll take some questions. So let's get started. First, I wanted to go over some basics, and those are the governing laws. So there's three types of laws that govern reasonable accommodation and modification requests. First, we have the federal laws, next, the state law, and the city law. The federal law that's applicable to us is the Americans with Disabilities Act of 1990 and the Fair Housing Amendment Act of 1988. The Fair Housing Act is the act that we're going to focus upon, and it governs housing and provides the federal standards, and it helped define a lot of the terms that we're going to deal with today. Next, we have the New York State Human Rights Law. It's the state law, and it is enforced by the New York State Division of Human Rights. Just as some background, the Human Rights Commissions and divisions deal with all discrimination claims, and disability is one of those types of claims. Next, we have the City Human Rights Law. The City Human Rights Law is governed by the Commission on Human Rights. It also deals with all discrimination claims and those based on disability. The City Human Rights Law is going to be the most stringent of the laws, and it's often the leading edge on what constitutes a disability and what kind of relief a tenant can get. So under all these types of law, tenants can bring private causes of action in state or federal court, and these laws are not inconsistent with each other, and they often work together to get relief for a tenant. Next slide, please. The next topic we're going to discuss is, what is a disability and who is covered? So a disability generally covers any kind of physical mental, or psychological impairment. There's different definitions of what constitutes a disability based on the applicable law. So under the federal law, they define a handicap as any physical or mental impairment which substantially limits one or more of a person's major life functions. So those major life functions include basic things like walking, talking, seeing, speaking, and working. Meanwhile, the state and city law don't have a requirement that a disability affect a major life function. These laws are substantially broader in scope. For example, the state law covers any physical, mental, medical, psychological impairment that prevents normal bodily function. And all the tenant needs to do to support their claim is to provide some kind of medical evidence or record of the disability. The city law is even more broad in their definition of a disability, and it covers any kind of physical, medical, mental, or psychological impairment which the tenant can show there is a history of. In the context of housing, all of these laws cover people that are tenants and occupants, and they also cover any applicants for housing. Next slide. So we'll go through a few basic examples of disabilities. First, physical disabilities. The most common type of physical disability is some kind of orthopedic condition, which is a condition that prevents someone from normal mobility. Generally, that means it prevents their ability to walk or go upstairs. This is the most common issue. It doesn't need to be obvious. It doesn't need to be that someone is confined to a wheelchair, but if they have some kind of limitation, they could qualify for having a disability. Other physical disabilities are visual impairments, speech and hearing impairments, cerebral palsy, epilepsy, diseases like muscular dystrophy, multiple sclerosis, cancer, heart disease, diabetes, arthritis, and lung diseases. So oftentimes, an individual may have some of these conditions. Perhaps they have heart disease, diabetes, and arthritis, and this together contributes to some kind of disability that prevents them from normal life functions. The other types of examples of disabilities are mental or psychological disabilities. These include bipolar disorder, schizophrenia, autism, general anxiety disorder, and developmental disabilities. These conditions tend to be less obvious, but they can come out in the course of litigation or while dealing with a tenant. The next slide, please. So the two terms of art that we need to deal with are what is a reasonable accommodation and what is a reasonable modification. The key word is reasonable. There's no requirement to do everything that a tenant asks for, but we also need to determine what an accommodation is versus a modification. So first, for an accommodation, it's a change in rules, policies, practices, or services necessary to give people with disabilities an equal opportunity to use and enjoy their homes. So essentially, this is going to be providing an exception to a rule for a disabled individual to deal with their condition. Generally, these don't present a significant cost to the landlords. And next, we'll move on to what is a reasonable modification. A reasonable modification is usually a structural change to the existing building for a person with a disability to live in and use the premises. So generally, this involves the installation of some sort of physical aid for the disabled persons. Costs can range from minimal to quite significant, depending on what the request is and what is needed to accommodate the disability. So in sum, the real difference between the word accommodation and modification is that an accommodation is a change in rules, while a modification is a change in the physical layout of the building. These differences matter under state and federal law because the differences between modification and accommodation are used to determine who is responsible for paying for either the accommodation or modification. However, under the New York City law, generally the owner is responsible for paying for either the modification or accommodation unless there is some sort of undue hardship. Especially in New York City, the term reasonable accommodation tends to encompass both a accommodation where you change the rules and a modification where there's a physical change to the building. So in New York City, the term reasonable accommodation is going to be used for both. Next slide. All right, speaking about financial responsibility. So ultimately, who has to pay? So a reasonable accommodation, again, which is a change in the rules of the building, under the federal, state, and city law, the owner generally has to pay for the accommodation and change in rules. Again, these are usually not a substantial burden. However, if there is some kind of undue burden because of a change in rules, then the owner would need to prove that changing the rules is not possible. For a reasonable modification, which is again a physical change to the building, under the federal law, the tenant is responsible for paying for the change in the building, and the tenant is responsible for making arrangements to return the building back to its original state. Sometimes tenants will be required to escrow monies, so once they leave, the owner can return the building back to the original state. But under New York state law, the owner is obligated to pay for modifications, physical changes to the common areas of the building, like the lobby, entrances, and hallways. Meanwhile, the tenant is responsible for paying for the modifications to the apartment. So New York state law says common areas, the landlord is responsible. Inside the apartment, the tenant is responsible for paying for it. And then finally, for the city of New York, the owner is generally responsible for paying for all modifications. The only issue is whether or not the request poses an undue hardship upon the landlord. So let's go to the next slide. So after you've received your request, what do you need to do? Upon receipt of the request, you need to document your interactions with the tenant. It's important, whether it's in writing or orally, to note when the request was made by the tenant. This is because owners are obligated to take requests seriously, and the failure to provide a timely response can be deemed a denial of the request. So after you receive the request, you're required by law to enter into what's called cooperative dialogue. This would mean that you would engage in a dialogue where you get information from the tenant, discuss their request, and ask for any kind of additional documentation that you might want. It's important at this stage to document your dialogue with emails or letters and show that you're working to resolve the issue. Next, you evaluate the claim. We're going to discuss that in more depth in a minute, but basically you're going to look at the tenant's request, the requirements of the law, and determine if the tenant's request is reasonable. If you determine that the request is reasonable, then you're legally required to provide the requested accommodation. And then finally, after you evaluate the claim, you should provide a written response to the tenant stating whether or not you accept their request, whether or not you're denying their request, the reason for denying the request, or if it makes sense, you could present an alternative to the tenants to accommodate their disability. Next slide. So when you're evaluating a claim for an accommodation or modification, first I'm going to focus on the claims in New York City because those are the most stringent requirements and they're going to impact the most individuals that make these sorts of claims. The first issue is that you have to investigate the disability. You have to evaluate whether the tenant has a covered disability. To this end, the owner is permitted to ask for information regarding the disability. But remember, as we just discussed, disability can be quite a broad term. The tenant could present something as simple as a doctor's note or some limited medical records to substantiate the claim that they're disabled. Investigating the disability is not an excuse to pry into a full medical history of the tenant. If the condition is obvious, so if a tenant were blind or in a wheelchair, generally you shouldn't need to investigate the disability. Moving to the next topic, we're evaluating modification, which are the structural change requests. So under the city human rights law, a reasonable accommodation is anything that does not present an undue hardship to the owner. And it's the owner's obligation to provide, to prove that by providing the accommodation, they would encounter an undue hardship. Courts interpreting the law have said that no accommodation is unreasonable that does not present an undue hardship. So as an owner, one needs to determine whether the tenant's request is an undue hardship. And if it is not, then the owner should provide the reasonable accommodation. But the issue is, what does undue hardship mean? The problem with the term undue hardship is that it's a relational term and it's very fact specific. The issue is whether or not the particular request made to you as the particular owner is an undue hardship to you. No two owners are necessarily going to have the same types of issues. No two tenants are necessarily going to have the same types of requests. But there are certain factors that you need to look into to determine whether or not there is an undue hardship. The first is the total cost. If the cost is prohibitive and your financial means prevent you from being able to afford it, then that could be an undue hardship. But you have to remember that your finances are going to be used to determine whether or not it's an undue hardship. So a smaller landlord is going to have less of an obligation than a larger landlord. The next issue or factor to consider is whether the requested change or modification is impossible or impractical. If an owner thinks that something requested is impossible, it is good practice to hire an expert, say an engineer, an architect, to speak to the issue. Some examples of when something is impossible or impractical: if you had a 4-story brownstone, it would be impossible to put an elevator in there. But that shouldn't limit your ability to deal with the accommodation request, and perhaps you make alternative means for dealing with the tenant's issues. And then the final factor to look at is whether or not the request causes damage to others or potentially causes damage to others. Again, it's the owner's obligation to prove whether or not the request made by the tenant is going to cause damage. So some examples of routine structural changes are installing a wheelchair ramp, putting grab bars in an apartment, widening doors, putting chair lifts in a building. Something, like putting grab bars in apartments, generally, if you look at the factors, the cost factor is generally minimal. Generally, putting in grab bars is not going to be impossible, and it's not going to cause damage to others or potentially cause damage to others in the building. So that's the type of thing that an undue burden, an undue hardship is going to be unlikely for a tenant, for a landlord to show. Meanwhile, something like a wheelchair ramp is much more fact specific, and if these are the types of things that could be an undue cost, depending on the size of the owner and their financial ability, and whether or not a wheelchair ramp is practical based on what an architect can tell you on that issue. Next, when you're evaluating accommodation, which are changes in rules, the federal, state, and local laws all provide that the owner is generally responsible for paying for the accommodation and rules. And in New York City, the issue is whether, again, the change is an undue hardship. Generally, these changes in rules are not undue hardships, as cost is generally not an issue. So if a tenant is clearly disabled and the request meets their needs, the tenant should be provided the accommodation. Some basic examples of accommodation requests would include allowing a guide dog or emotional support dog in the building, giving a disabled tenant reserved parking, providing disabled tenants priority for services, allowing tenants to seek treatment to stop nuisance behavior, allowing the installation of appliances that are otherwise prohibited by the lease, and providing porter services if the elevator was out, for example, to help with carrying groceries and supplies. While generally these don't pose an undue burden, as an example, if someone had exhibited nuisance behavior in a building, there's no obligation by the landlord to keep the tenant in there if that nuisance behavior continues. But as Michael will tell you in a few minutes, an accommodation might be to allow them to get treatment and deal with the issue. So the object here is not to give a disabled tenant an advantage, but it's rather to give them equal enjoyment of the premises as any other able-bodied adult. And with that, I'm going to throw the presentation to my partner, Michael Littman.
Thank you, Arun. And good afternoon, everybody. Thank you for having us, and I hope everyone is healthy and doing well. If a tenant is not satisfied with your response to their request, they have a few different options that are available to them. They can sue you in state court, federal court, or before administrative agencies. It's important to note that denying a reasonable accommodation request is considered discrimination under the law. A tenant can sue a landlord in the following forums: federal court, New York State Supreme Court, Housing Court, the Department of Housing and Urban Development, also known as HUD, the New York State Division of Human Rights, or the New York City Commission on Human Rights. Each forum provides different relief to tenants. When a tenant sues in federal court, they are generally looking for two things: financial relief or an injunction from the court. The financial relief a tenant can receive includes compensatory damages, which means that they're seeking money for actual losses that have occurred, damages for emotional distress, punitive damages for improper conduct, and attorney fees. Tenants can also seek and receive injunctive relief in federal court. The court can issue an order, for example, requiring the implementation of the reasonable accommodation requested. Tenants can also get a stay from the court to prevent the owner from taking an action, or can issue a preliminary order requiring an accommodation to be provided pending the resolution of the action. If a tenant sues in New York State Supreme Court, tenants are able to receive similar relief to those that I just discussed in federal court. These issues can also be raised in housing court as well, and are generally in the context of a tenant interposing a counterclaim or raising a defense to a landlord's claim. Meaning, if a landlord sues a tenant either for non-payment of rent or for a violation of a lease term and a holdover, a tenant can interpose a counterclaim or raise a defense. A housing court judge has the power to direct an owner to provide a reasonable accommodation by order of the court. However, the housing court does not have jurisdiction for claims of monetary damages. Next slide, please. A tenant can also file a complaint with HUD. If a tenant files a complaint before HUD, HUD acts to investigate the claim before determining if there is or is not probable cause that the landlord or owner has engaged in or is engaging in the unlawful discriminatory practice complained of. If a determination is made that there is no probable cause, then the complaint will be dismissed. HUD has the following relief that it could provide to tenants. They can issue an order to stop the conduct or provide a reasonable accommodation. They can issue an award of compensation for actual damages, also damages for emotional distress, expenses, attorney fees. HUD also can award civil penalties. These civil penalties can reach up to just a little bit over $21,000 for a first penalty. For a second violation within a 5-year period, up to $52,596. And if there are 2 or more previous violations in a 7-year period of time, up to $105,000. It's also important to note that HUD will also refer these complaints that it receives to the New York State Division of Human Rights sometimes. And that brings us to the New York State Division of Human Rights. These claims are investigated just as HUD does. And the relief is almost the same except for the civil penalties, as you can see. They can issue an order to stop the conduct or provide a reasonable accommodation. They could issue a decision for compensation for actual damages, damages for emotional distress, expenses, attorney fees. Punitive damages are capped at $10,000. They can also assess civil penalties, fines up to $50,000 for non-willful actions, or up to $100,000 for willful actions. Lastly, claims can be brought at the New York City Commission on Human Rights. The commission investigates claims just like HUD and the state do. They also provide the following relief. They can issue an order to stop conduct or provide a reasonable accommodation or other relief, compensation for actual damages, emotional distress, expenses, attorney fees, criminal penalties. They can also issue civil penalties with fines up to $125,000 for non-willful actions and fines up to $250,000 for willful actions. As you can see, the New York City Commission can impose the highest amount of monetary penalties against an owner, as well as criminal penalties. They could also require an owner to undergo training. Here are some litigation considerations that an owner can think about. If an action is brought before an agency, a landlord is subject to substantial fines. In all forums that I have discussed, a landlord will be required to hand over documentation, including the owner's written policies and procedures on modification and accommodation requests from tenants with disabilities, contact information for other tenants in the subject building, and also, depending on the claims and defenses, a landlord may also be required to provide their financial information. If an owner claims undue hardship, the question is who has to prove it? In New York City, it's the owner's burden to prove. If an owner makes a claim of financial hardship, the owner will need to provide financial documentation and proof of cost to make the requested accommodation. If an owner is making a claim that the request is impossible, then the owner must support the claim with documentation, statements from relevant experts such as architects, engineers, or attorneys. Lastly, I want to go through the typical reasonable accommodation requests. Generally, tenants with physical mobility issues will request the following: wheelchair ramps, widening of doors, installation of grab bars, wheelchair lifts, and retrofitting doors. The most common request is a request for a wheelchair ramp. The first consideration that you have to make is the cost of the ramp. The owner's financial ability is considered to determine if the cost is an undue hardship. An undue hardship, as Arun said earlier, to one small landlord may not be the same undue hardship to a large landlord. For example, in 1999, so 20 plus years ago, the New York City Commission on Human Rights determined that $50,000 was not an excessive burden for a co-op building. The second consideration is practicality. An owner must prove that it cannot practically place a ramp at the property. For example, issues that can make it impractical are grading of the building relative to the sidewalk, the area available in front of the building, entrance size, etc. An architect or an engineer should be hired to determine if a ramp can or cannot be installed in compliance with city ordinances. But keep in mind there are also alternative options. If a ramp is sufficiently deemed an undue burden, then you should consider alternatives like a wheelchair lift or tenant relocation. As I just said, tenants may also request relocation of their apartment. For example, tenants with physical disabilities may request to be relocated to a ground floor apartment. Generally, when this type of request is made, a tenant will request that their rent in their current apartment be kept the same and transferred to their new apartment. So an undue burden analysis must be undertaken. Again, the owner's financials will be considered, and no two landlords are identical. The issue is whether the loss of rental income should be considered an undue burden. Under the newly enacted Housing Stability and Tenant Protection Act of 2019, it may be likely that moving the tenant to a new apartment and taking their old rent with them will be an undue burden on a landlord due to the new restrictions on increasing rents in rent-stabilized apartments and the restriction on deregulating apartments based on high rent vacancy deregulation. Elevator upgrades or renovations. If an elevator is rendered out of service for a period of time during upgrades, an owner may be required to accommodate disabled tenants depending on the time frame of the outage. Regardless, notice of the outage and predicted amount of time should be provided to all tenants. If a longer project is expected, consideration must be given for relocating tenants to ground floor apartments or to another building. There are also alternatives, which may be assisting tenants with daily activities by providing a porter, for example, to take laundry or groceries, etc., up and down in the building. There are also reasonable accommodations that could be provided to a tenant who is a nuisance in the building. If a tenant creates a nuisance in the building, an owner may be entitled to seek possession of the apartment in housing court through a holdover proceeding. In the context of those cases, the tenant may seek a reasonable accommodation, which could be a probationary period of time for the tenant to correct his or her actions. Recently, I settled a case for a landlord in housing court with a probationary period of time that we provided to the tenant as a reasonable accommodation for a tenant who suffered from many mental diseases and was a nuisance in the building. In this context, disability is generally mental or psychological. If the tenant seeks treatment for their disability and stops the nuisance behavior, the court may require an extension of a probationary period for the tenant to correct or stop the nuisance behavior. Emotional support animals. These animals are separate and apart from dogs that are used by individuals with physical disability. Emotional support animals are claimed by individuals with mental disorders, the most common being a claim of anxiety. If a tenant is able to prove a disability and show that the animal is necessary to treat the disorder, then the tenant will be able to keep the pet regardless of a no pet clause and a lease. However, the tenant needs to be able to prove their disability. The New York City human rights law does not, however, require the animal to be a dog or specifically trained. The issue is whether it helps the person with their disability. And obviously, the pet should not be dangerous to others or otherwise a nuisance, and it cannot be an animal that is illegal to have in that state or city. Parking spots. Tenants with physical disabilities generally will be accommodated by being provided with a parking space that is easier to access and is close to the entrance, regardless of any policy to the contrary. Lastly, apartment appliances. Tenants with physical disabilities may be allowed to install appliances like washing machines, dishwashers, or dryers, even if not permitted under the lease or building rules. An owner is not obligated to provide this accommodation if it's impractical or will cause damage to the building or other tenants or other apartments and tenants in the building. And thank you for your time, and I think we'd like to open it up for questions at this time.
Okay, thank you very much. I think I'll put my camera back on. Yep, there I am. Whoop. Okay. Seeing me isn't important. I'm going to go back to this slide over here. So in case anyone wants to contact you to follow up afterwards, they can. And I will start with the first question. A tenant who uses a wheelchair wants me to install an automatic door opener for her apartment door. Must I do this? And if so, can I charge her for it?
So thanks, Heather. I'll answer that, which I discussed earlier. It depends on where you are. So if this was in New York State, but not in New York City, then the tenant would be obligated to pay for it because the argument would be made that it has to do with something in their apartment. Now, in New York City, the issue is whether or not this is going to be an undue burden. So if you are a smaller landlord and something like this is extremely costly, perhaps you wouldn't have to pay for it. But in general, unless you can prove that undue hardship, maybe it's impossible to put it in there for whatever reason. But if you can't prove that undue hardship, then you're going to have to install the automatic door.
Okay, someone asks, is excessive weight, 400 pounds, a disability? Tenant wants apartment building accommodations due to her weight.
So, I mean, the simple answer is yes. More likely than not, if that's impeding her ability to function, then her excessive weight, if that's making it difficult for her to walk, and it makes it difficult for her to go up and down stairs, that would constitute a condition that at least, at the very least in New York City, would be considered a disability. Even under the federal law, does it impair a major life function? Does it impair her ability to walk? Probably. And if she can show that, then it would qualify.
Okay. It's too difficult for a 95-year-old tenant to open the fire escape window. Wants it replaced with a window that's easier to open. Would that be a reasonable modification?
I think absolutely yes. Even putting this whole thing to the side, do you want to have a 95-year-old tenant who requested you to put in a window to make it easier for her to escape in case of a fire? I think the answer is obviously yes. So this is definitely something that a landlord should do immediately.
Okay. Many residents who claim to be asthmatic request flooring to be changed from carpets to other material. Is this a reasonable accommodation, and who is responsible for paying for it, if it is?
So back to payment, I mean, in general, like I discussed, if it's in New York City, the landlord's going to be obligated to pay for it. So then the question is, in this particular, my question would be, is the installation of carpeting really going to address something that's considered a disability? I mean, I'm not a medical expert, but asthma, there could be a range of issues with somebody with asthma. So there may be some people that installation of the carpeting would make a difference, but I don't think you should just take it at face value. You're entitled to look at whether or not there's some kind of expert, maybe their doctor gives them some kind of indication that that's going to address some kind of issue. I mean, asthma, if it's limited asthma versus something that's really a substantial issue because of carpeting, that would be the issue there. So it'd be very fact intensive to determine if the disability, in this case asthma, is significant enough.
When you ask a tenant for a note from, say, a doctor, what are you allowed to ask for? I mean, you're not allowed to ask for the tenant's complete medical file, are you?
So if the tenant ultimately is putting their medical history at issue, so you're entitled to look for medical records within reason. Not everything needs to be put in front of you, but anything that's relevant to this issue, I mean, it should be tailored to this specific issue. But if the tenant is saying, I have severe asthma that causes me, some sort of disability, then they need to substantiate that with something. A doctor's note or actual medical records would be within the landlord's rights to ask for it.
Okay. Someone asks, recently an applicant submitted proof from a doctor for an emotional support animal based on her stress levels. I called the number on the letterhead, there was no address, and it was an online referral service. I went on the website and answered all of the questions to qualify for an emotional support animal myself, answering all the questions in the opposite way. I am not stressed, I am not anxious. At the end of the questionnaire, it responded, congratulations, you qualify for an emotional support animal. Obviously, this is a scam and the applicant is not even being examined by a doctor. The doctor supposedly just reviews the questionnaire I filled out. What can an owner do to fight a scam like this?
Well, first, the owner can insist, again, that the tenant prove their disability. I don't think that particular tenant has done so by filling out this online questionnaire, which doesn't seem to have come from a medical doctor. So the landlord can request that the tenant prove that they have a disability and show that the animal is necessary to treat that specific disorder. Without doing so, you don't have to allow them to keep the emotional support animal, but you should request that documentation from them.
Okay, here's a related question. An applicant who qualifies for an apartment in my building has a potbelly pig she claims is an emotional support animal. Must I allow her to keep this animal in the apartment? We allow pets, but only dogs and cats.
So, as I just said to the last question, if the tenant can provide proof that they have a disability and show that that animal, in that case, a potbelly pig, is necessary to treat the disorder, then the tenant will be able to keep the pet regardless of a no pet clause in a lease. But if that pet is dangerous or otherwise a nuisance or illegal, then the tenant would not be permitted to keep it. In New York City, the law does not require that the animal be a dog or specifically trained. The issue is whether it helps a person with their disability.
Okay. Given all the new laws in New York City, can I tell the tenant to hire their own contractor to put grab bars around the entire apartment, and I will put in the bathroom and toilet grab bars? So maybe
I'm not sure what the new laws the questioner is referring to, but again, it's location based. I don't think grab bars are the type of thing that are an undue burden in most cases. So if it's New York City, the landlord's going to have to pay for it. If it's not New York City, if we're talking about Nassau County, then the tenant does have to pay for it. But I'm not sure what the new laws they're talking about are.
Okay, it sounds like this tenant wants to put grab bars in places that are not standard, like in a bathroom, but all around the apartment.
Okay.
I'm wondering, after that tenant moves out, can the landlord use a security deposit to restore the apartment to its original condition by taking out some of the unusual placement of grab bars?
So if we start with the premise that the tenant is responsible for paying for it, then the owner can make arrangements once they're installed to have the tenant escrow monies into some kind of fund to show, a few $1,000s here, so that once you leave, I can remove all the grab bars. So you would start that process early on. Using the security deposit, I think that takes into consideration other issues. You should start in the beginning saying, we have this issue, we're going to have to remove it when you leave. You need to put a certain amount of money up now and show that you've escrowed it, so that once you leave, we can apply that.
Okay. Does the owner have to pay for a washer installation? I think you've just answered that, yes, in New York City, if the washer is a reasonable accommodation or modification.
The only thing I will say about that is, it depends on the building. Some of these older buildings can't handle washing machines and dishwashers. So if the pipes can't handle it, and you can prove this as the landlord, then you can make the argument that this is going to cause flooding, this is going to damage other people in the building, so therefore I can't install a washing machine or a dishwasher in your particular apartment. Or, let's say to upgrade the piping, it costs hundreds of thousands of dollars, then that would be an undue hardship. But if it's just one and you could do it, then you're probably going to be obligated to.
Okay. Do these laws apply to cooperative shareholders or only tenants?
They do apply to cooperative shareholders.
Okay. When you have an emotional support animal or guide dog, what is the level of disturbance caused by the animal which might sustain a holdover? I guess if the assistance animal or support animal is causing a nuisance, what are your remedies?
So, I mean, in any type of nuisance holdover, you need to document what the dog is doing. I mean, there's a lot of things that could be a nuisance with a dog. A dog could attack people. A dog could be not properly trained, and it's causing a mess everywhere in the building. It really depends on the particular situation, but I think the best shot is if it's a danger to others, there's like recorded incidences of it attacking people, or if the tenant just does not take care of their dog in any reasonable manner, that would be another reason that I could think of.
Okay. Besides relocating tenants to another apartment or building, what would be some other reasonable accommodations or modifications to make while an elevator is being modernized in a single device building?
One alternative that I think both of us spoke about would be assisting tenants with their daily activities by hiring someone, if you have a porter or a super in the building, to take their laundry up and down or their groceries, etc.
Okay. How much in New York City constitutes burden on the landlord in a rent stabilized with one building? Not sure I'm reading this correctly. But I guess the question is, for a small rent stabilized landlord, what financial threshold would constitute a burden?
So I'd love to say that $10,000, you don't have to pay a penny more. unfortunately, the way that the law is, it's relational. So it depends on your profit. So let's say, for example, you have a small building, the 6-unit building, and you're not doing well this year. Obviously, we're in the middle of the COVID pandemic. Nobody's paying their rent. So say you're operating at a loss, then most substantial costs would be considered an undue burden for you. But again, it's so fact specific. I couldn't give you a specific answer, but it really boils down to, can you prove it? So if you can show that you're not making any money on this building, and you have no other buildings, and you're really suffering, then it would be an undue burden.
Okay. Someone asks, are there substantial differences in jurisdictions outside of New York City? I would think New York City would be the most restrictive jurisdiction.
Yeah, New York City is going to require you to do the most, pay the most, and it's going to require the least out of the tenants. I mean, I'm going to focus on New York State because those are the areas that we're most familiar with. New York State, you do get some ability to have the tenants pay for certain things. And for example, we were talking about dogs or service animals. New York State defines a service animal as a dog and requires it to have training. So there are definitely more restrictions outside of New York City, and New York City is just going to be the biggest issue, though, ultimately.
Okay. A tenant with disabilities has asked us to install grab bars, lower light switches, and make other modifications to make her apartment more accessible. There's a vacant apartment in our building that already has these accessibility features. We've offered to move her at our cost to the vacant apartment, which is the same size as her current apartment, but she's refused. Since she refused our offer, do we still have to make the requested modifications to her apartment?
So the simple answer is yes. In New York City, the requirement is to provide the accommodation if it's reasonable and an undue burden. So unless something is missing here that I don't see, I don't think that this would be the type of thing ultimately that you could argue is an undue burden. I mean, it's unfortunate that that particular tenant didn't want to compromise in any way, but if it came to it and you went into litigation, I would tend to think that the tenant would be entitled to get the grab bars and switches in their apartment.
Okay, I'm just scrolling through some of the questions. Some are overlapping with other ones that we've already answered. So bear with me. Oh, I see Haya is chiming in.
I am. I'm going to say we have time for one more question. At exactly 2 o'clock, the webinar will end quickly, and I want to be able to thank everyone. So
Sure.
Okay.
time for one more, I believe.
Okay, let's see. The pressure's on me. I'm scrolling through these. Okay, ask that one. Okay. This is regarding when you said that you could move tenants from one apartment to, say, a ground floor apartment, and someone saying, how can you do that when you have older people living on the ground floor and living there over 30 years? So I guess the question is, can you move other tenants to accommodate disabled tenants?
So no, you don't have to move other people. It still has to be reasonable. If you don't have the ability to move someone because you don't have any other units, you could put them on a wait list, and you say to them, once the first floor gets a vacancy, then we'll move you down there. You just have to show that you've tried to do it in that context.
Okay. Well, if I didn't get to any questions, if I missed something, we will be seeing the questions and we'll try to respond if we're able to. But thank you all for asking questions, and thank you, Michael and Arun, for the great presentation.
Thank you.
I would also like to thank both of you for an excellent presentation, a lot of very specific detail and specific questions answered, as well as some broad overview of everything that is changing and very topical. We're very grateful for you. Heather, thank you for all the work you did bringing this topic to our audience. I want to thank everyone who's participated on the webinar today. Please go to buildingsny.com. You can see all of the webinars, both the past ones on demand and the future ones coming up, and let us know what else you'd like to hear about. Thank you all. Have a good day.
Thank you very much.
Thank you.
Thank you. Okay, Tommy,